What is the purpose of the preference laws? The preference laws empower a bankruptcy estate to recover money previously paid by an insolvent debtor in a period prior to a bankruptcy filing. The law goes back into a period before the bankruptcy, in a period where everyone was operating under state law, and applies bankruptcy law retroactively to a period before the bankruptcy. It preempts and undoes contractual and property rights that are guaranteed under state law. All of a sudden, whether you've made a fair and legally binding deal to deliver goods or provide services is irrelevant. A bankruptcy trustee can simply throw all that aside, swoop in, and force a return of money rightly paid to you. In exchange for returning the money, a vendor gets a claim for a payment against the bankrupt company and can expect pennies on the dollar in many months or even years, or never. It's a very dramatic and shocking law because it sets aside and undoes law, not now, but up to 2 years ago. Laws that apply retroactively are rare. Laws that preempt prior settled law are also very rare. What about a law that does it all? Retroactively preempts settled law in a prior period of time. I really don't know of any other laws that do that except for the bankruptcy clawback laws. Why do we have them? Why do we have these laws? The problem the preference laws try to solve. Preference laws, which are hundreds of years old, try to solve one very thorny problem. I'm going to describe a hypothetical situation which hopefully will help you understand the problem. Consider this hypothetical. We have a debtor, either a company or an individual, that owes money to two creditors. Creditor number one, creditor number two. The debtor owes $10,000 each to both of them. So it owes a total of $20,000. Unfortunately, business has not been good, and the debtor only has $10,000 left in total assets. Things are so bad that the debtor files for bankruptcy and liquidates. However, before the debtor files for bankruptcy, it pays creditor number one the full $10,000 that creditor number one was owed. In other words, it pays all of its assets to creditor number one instead of paying each creditor 50% of the assets, which would be more fair. Creditor number two is left out in the cold. After making the payments to creditor number one, the debtor company files for bankruptcy. The bankruptcy judge appoints a bankruptcy trustee to distribute the debtor's assets, and of course, there are no assets to be distributed. Creditor number two gets nothing from the bankruptcy distribution because there's nothing to distribute. Creditor number two later finds out that the debtor paid creditor number one all of its money the day before the debtor filed for bankruptcy. So now creditor number two, not happy, does not feel that this was a very fair way to distribute the debtor's assets. Upon finding out about the unequal distribution of assets, the bankruptcy trustee agrees and files a preference lawsuit against creditor number one. Now, creditor number one is not happy. Creditor number one says, I was owed $10,000, like I paid $10,000. I should get to keep my money. Whether the debtor did or did not pay other creditors is not my problem. Why is this suddenly my problem? Has the law suddenly changed to say that I'm now responsible for other creditors getting paid? This is my money, and I'm not returning it just because some other creditor did not get paid. The unfairness of clawing back rightly paid money versus equitable treatment in bankruptcy. It's not fair to go back in time to before a bankruptcy and wipe out fair and established property rights and claw back money that was rightfully paid to a creditor. After all, if creditor number one knew a bankruptcy trustee would later swoop in and claw back his money that was rightly paid, he would have chosen not to do any business with this debtor. However, it's also pointless to have a bankruptcy system, the main purpose of which is to divide up assets equitably among creditors if, right before bankruptcy, a debtor can pay all of his assets or a substantial part of its assets to a favored creditor, leaving all other creditors with nothing. Allowing pre-bankruptcy payments to some creditors could preempt the bankruptcy laws, resulting in many folks not getting paid any share of the debtor's assets or a much smaller share that they would otherwise be entitled to. It's a tough problem because fairness to one results in unfairness to other creditors. That's the preference problem. Solution to the problem. The court's first solution to this problem historically was to look at the intent of the parties. For example, what if creditor number one knew that the debtor did not have enough money to pay everybody and also knew that the debtor was about to file for bankruptcy? What if the creditor conspired with the debtor with the clear intent of forcing payments to itself and escaping an upcoming bankruptcy? In this situation, forcing this creditor to return the money to a bankruptcy trustee seems a lot less unfair. This was in fact the law for hundreds of years. The bankruptcy trustee was required to prove bad intent before he could successfully claw back money from creditors. In their defense, the creditors could also assert good intent. The problem here is that subjective intent was extremely difficult to prove, and therefore the bankruptcy trustees ended up clawing back very little money. The equitable division of the bankruptcy assets of the debtor were thus continually thwarted by significant pre-bankruptcy transfers. In 1978, after about 400 years, the law was suddenly changed so that the bankruptcy trustee no longer had to prove bad intent. Instead, the recipient of a preferential payment was allowed to show as a defense that the payment was made in, quote, the ordinary course. The theory behind the current ordinary course defense is that the debtor paid an innocent creditor who just happened to get lucky and get paid right before the bankruptcy. A creditor proves an ordinary course defense without testifying as to good intent, which is now irrelevant. The creditor shows an ordinary course defense by showing consistency with how the parties dealt with each other in the past before the debtor got into financial trouble. No change in the conduct of the parties is circumstantial evidence that the preferential payments were made in the ordinary course and were, quote, business as usual, close quote. Consistency with past conduct shows that the payments were paid in a way totally unrelated to the upcoming bankruptcy. I'll go into the details of the ordinary course defense in another video. The problem was partially solved. The solution to the preference problem is to force the return of payments made by an insolvent debtor to favored creditors unless that creditor can show evidence that the payment was made as business as usual and the creditor did nothing out of the ordinary to obtain that payment. In other words, preferred creditors can keep the money if they are innocent creditors. It's important to realize that if a creditor is paid in full while the debtor is insolvent, leaving other creditors unpaid right before bankruptcy filing, that creditor is preferred by the very nature of the circumstances. However, in balancing the equities, the law permits that creditor to keep the money if the circumstantial evidence shows that it was an innocent creditor. Like other compromises, the law is not perfect. If an insolvent debtor pays out all the assets in the ordinary course to innocent creditors, the result might well be that unlucky creditors who just happen not to get paid during the bankruptcy will never get paid. In this situation, the bankruptcy laws will fail to distribute assets equitably. On the other hand, there may be many creditors who received payment with good intent and without any knowledge of an upcoming bankruptcy, but are unable to prove consistency with past conduct and did not have an ordinary course defense. Lack of a perfect solution. The end result of the laws shows how difficult the preference problem is to solve. We have continued unfairness to many creditors exposed to the preference problem. In fact, the law's application results in an automatic unfairness to one or another creditor. If we claw back money, it's unfair to a preference recipient. If we don't claw back, it's unfair to an unpaid creditor in the bankruptcy. The best that the current law could do is take some steps to protect the bankruptcy system and stop the most obvious unfair situations, such as creditor-debtor conspiracies and obvious attempts to force or engineer favoritism. The second reason for the preference laws prevents a race to the courthouse. Let's change the hypothetical a little bit. In this hypothetical, both creditors, number one and two, sense that the debtor is in trouble and is running out of money. Both creditors gear up, hire lawyers, and rush out to sue the debtor in a race to grab assets before there are no assets left. The problem with this race to the courthouse is twofold. First, it rewards those creditors that are more knowledgeable or simply faster. This is antithetical to the purpose of bankruptcy, which is a systematic, fair, and equitable distribution of assets. Second, Permitting a race to the courthouse to prevail would encourage creditors to be even more aggressive, with the result, of course, that there would be no assets to distribute. The preference laws discourage a race to the courthouse, in theory, since creditors know they will be sued for preferences and they will simply have to return the money. The third reason for the preference laws: protect struggling debtors. Encouraging a use it or lose it creditor system might result in actually pushing a debtor into bankruptcy that had a chance of recovering financially, but for the creditor rush and pressure. In fact, in that situation, creditors with knowledge that a debtor is in trouble will increase its troubles and may push the company into bankruptcy. Why is that? A sudden increase in lawsuits and aggressive creditor actions might extinguish whatever chance the company had to get back on its feet. Not to mention that if one creditor suddenly becomes aggressive, it will definitely discourage other creditors from extending unsecured credit. Under this theory, the preference laws discourage this aggression by promising all creditors that should some creditors force payments before bankruptcy, a bankruptcy trustee will swoop in and force the return of the money. Essentially, this is like preventing a run on the bank by assuring all creditors that any assets that are removed through lawsuits will be returned, so that there is no need for aggression arising out of panic that there will be nothing left if one fails to act. So in conclusion, we have preference laws to try to prevent clear favoritism and strike a balance between clawback and unfairness to unpaid creditors, to discourage a race to the courthouse, and, in theory, to remove the need for creditor aggression. Whether the preference laws actually accomplish this is a topic for another video.